Hello everyone, welcome back to our channel, and today we've done a couple of videos like this before where we talk about what happened during our battle with UPS v. LTC, and today we want to talk about the topic of confidentiality and what should be confidential, how confidentiality is used in nefarious ways.
In our case, UPS was able to get pretty much 90% of discovery that they delivered. Discovery meaning emails, files, data, anything that they delivered to us. They were able to get the judge to pretty much everything get marked as confidential.
Yeah, so for reference, what is the definition of confidentiality? What does that mean in terms of a lawsuit case? What does that mean?
This is my understanding is files or whatever discovery that's that one party wants to be designated as confidential. Now there's two different levels of confidentiality. There's just something that's confidential, and then there's super confidential, which has the additional moniker of for attorney's eyes only. Ooh. So I really don't understand this whole process.
Well, there's a multitude of reasons that you could argue for something to be confidential. Here I have it pulled up right here. It's an AI overview from Google says information that should be considered confidential includes trade secrets, sensitive business financial information, personal medical records, social security, private customer lists, internal company communications regarding strategy. That's the one that's important for
regarding
us.
The strategy. So I suppose internal communications where, well, I'll just say, for example, employees are saying, yeah, we screwed up. Let's get prepared to pay them some money and apologize to them. That is not a secret. Yet in our case, those kind of communications were.
Yes.
Anything that made UPS embarrassed or made them look bad or made them look like they weren't following their own procedures or rules, all of that was marked confidential. What I learned after the trial is that our attorneys should have challenged all this stuff. Well, first of all, and I know you did some research on this, the judge should just not willy-nilly make everything confidential because one of the parties say, oh, we want everything secret.
Yeah.
But that's what happened in our case.
Yeah.
Linen Tablecloth had to deliver an enormous amount of discovery to UPS. And how much of that was designated confidential? How much of that did we request be designated confidential? Zero. Not a single document. Not one. Yeah. And how much of UPS delivered discovery was designated confidential? 90%. 90% of it. In fact, our previous lawyer said in his 20 years of practicing law, he had never seen that many confidential documents, that kind of confidentiality.
Yeah. Moreover, our current lawyer, who has dealt with class action lawsuits in the big ring, like with Uber and big names like that are on the same fighting level as UPS, he said that typically you'll see 5 to 10% of discovery is confidential. Something like 90% really should ring a bell for the court that happens. But you know, the process goes is that if you have a good cause, supposedly, there's no reason for the judge to say no to you.
But let's jump into what is the purpose of things being confidential? They should be a trade secret. Like, for example, you sue Coca-Cola, you can't have them like put their recipe in court for everybody to see, right? Okay, that's logical. Or if it's software, you can't have their code because, you know, Facebook's algorithm, whatever. So that's all logical. But emails that are embarrassing, no, those should not be confidential.
Yes.
Right? But in our case, they were.
Yeah, for things like that, what that kind of falls under, or what UPS must have argued it was internal communications regarding strategy. That is one of the things that is valid for deeming or designating as confidential information. But as we said before, these emails were regarding, oh, we did overbill them. They do have the right to, we do have to pay them this money back. That doesn't regard strategy in the slightest. That was a decision that was already made.
Right.
And that apparently is now confidential discovery. But additionally, that should also just be suspicious. Like, not 90% of what was requested, because I'm sure there's plenty more, we weren't really going for the jugular here. We were just trying to get our money back. I'm sure there's lawsuits where the intention is to bring down the company. And in that case, the discovery you're going to be asking for might be a bit more extreme. But for us to be asking just for our money back, and all of a sudden discovery is 90% confidential, as if they have so much to hide, that should reek of something's wrong.
So if you watched a previous episode Hansen and I did, there was a part where we had to cut out the name of a company that UPS actually helped do a rebate resolution with. I don't know if I can say that, but I'm going to anyway. It's called a rebate resolution, all right? It's an internal thing about when UPS analyzes overbilling and gives money back to the customer. Well, they did it for a very big customer. And the name of that customer is confidential. We can't say who it is, which is ridiculous. But judge granted it. So
yeah. That's like a king saying, oh, I fixed the issue that he created himself so that he can be raised up by the people. That's not a positive thing.
Well, we don't know what happened with this big company. No. Maybe it was an inadvertent mistake or a software glitch or something. We don't know if they did it on purpose. Like in our case, they knew exactly what was going on.
Purpose, not purpose. It's their job to bill you fairly. So even that way, then they just look incompetent.
Obviously, you haven't read their contract. Their contract says, no, they can bill you for packages you don't ship, and they can bill you for packages that are wildly overstated. Everything is your fault. It's all your fault, and you can get your money back, but you have to figure it out.
You're supposed to.
And you have to figure it out in 180 days, and you have to hold our feet to the fire and force us to give you your money back. That's all.
Their
that's
whole
fair.
Entire upfront fluff is that they're supposed to be fair, but
yeah, and so fair dealing laws and common laws of theft and lying and all of that. No, all that goes thrown out the window because they have a federal preemption, which is their freaking Marvel shield that stops everything.
Marvel shield, vibranium shield.
What is it called?
Vibranium. That's the metal that's able to absorb and give back.
And which character has that?
Captain America.
Oh, Captain America.
Yeah, Black Panther has it too. So in regards to the process of designating discovery as confidential, it goes more so like this, Both parties will request discovery, then the party requested will give the discovery, but they might mark things as confidential. What they want as confidential, they'll mark it as such. And then they'll tell the court, this is why I want this to be confidential. They'll give a good cause. And in our case, they provided the discovery, it was 90% confidential, and that should be a red flag for the judge to say, okay, well, they gave a reasonable cause, but is the stuff that they're actually saying what it is it actually that? Is it justifiable by their cause, or there's other things that they snuck in there that aren't exactly justifiable by that cause, but they're just using it as like a blanket
thing, and sorry to interrupt you, but also the judge has an obligation to look at it and say, if I designate this as confidential, is it fair to both parties here? So if it's just an email that might embarrass you, that's not a good reason to make it confidential, especially if that email is crucial to the other side defending themselves or presenting their side of the story at court, which is what happened to us.
For all we know, the judge may have either not looked at it or turned a blind eye. We don't know. But beyond that is the job, the other side can then go through this information and say, okay, well, should this really be confidential, or does their cause really justify this being confidential? Then you can come back, you can have that battle with the court, and you can get it not confidential if you win that. And this is the thing when you're punching on the big leagues with UPS as just a small company like us. Of course, they have so many lawyers around the clock. How many lawyers?
They had 9 lawyers in Los Angeles, San Francisco, and New York, plus probably a dozen paralegals. We had 2 lawyers.
Yeah.
Plus, let's be honest, there's the intimidation factor too.
Yeah.
This is UPS with all their financial might and the top lawyers in the country, and our lawyers are like, ooh, we don't want to make a mistake, so we're not going to be aggressive.
it's a whole combination of issues that you're up against in this situation and it's partly because of the system. There's no guarantee that you're going to have even the capability to defend for yourself, because the judges, though they don't always look through all the discovery. And if when it falls to us to do it, we might not even have the capability to do so, and we might just not even have a chance to fight before the fight starts, because then when 90% of all our discovery is confidential, what can we even show the public? We can't even fight with that in trial anymore.
Which, to wrap this up, that's exactly what happened. So not to get too far in the legal weeds, but before a trial starts, there's a motion called motions in limine. And that's where both sides say, we want this excluded from the trial. This. UPS was successful in getting pretty much everything excluded. We could not talk about how much we thought we were overbilled. We couldn't even put the number up, even though my wife did at trial, which created a sidebar, and it was kind of an interesting moment. But we couldn't talk about the emails we'd read. Basically, our case was gutted before the trial even started.
Yeah.
That's the power that UPS and these huge companies have, the
Yeah.
power and influence they have.
That's the greatness of our legal system, is that,
Yeah.
funny enough, the pre-trial was 99.99% of everything that happened here, and discussing what we get to even say in trial.
Yeah.
It's kind of crazy, is that we spent all that time arguing what we had to say in trial, when it's like, we have things to be said. Why can't we say them?
I still don't understand it.
Yeah.
You know, as old as I am. And so I said this in a previous video. If anybody thinks our legal system is fair, I did before this trial. Man, have my eyes been opened. There is nothing fair about our legal system. It's whoever has the most power, the most money, and the most influence. That's the side that usually prevails. So think about that when you just willy-nilly throw around, I'm going to sue you. Think about that. Really think about that.
Okay, so as always, thanks for watching, everyone. This is probably going to be a longer video, a more mundane video, but again, thank you for watching, and be sure to subscribe, hit that notification bell so you can know when we post another video.
Yes, because the next one that's coming up, if you ever are involved in a lawsuit, I hope you're not, but unfortunately, it does happen, hiring a big law firm, whether or not you should, how to deal with law firms, how to deal with lawyers, how to oversee them. There's actually a lot to know. And if you don't know, you're going to get screwed. So
Yep,
stay tuned for that one.